You'll remember from an earlier lecture that in order for a legal contract to exist, there has to be 4 elements, and those are an offer, acceptance, consideration, and the intent to contract. In the last lesson, we looked at what constitutes an offer, and in this one, we'll look at what constitutes legal acceptance. Acceptance is an unqualified willingness to enter into a contract on the terms of the offer. This occurs when an offer made by one party is unconditionally and unequivocally accepted by the other party. If the acceptance doesn't mirror the offer, then it's actually a counteroffer. And when there's a counteroffer, the original offer is said to no longer be alive. So remember, a counteroffer is actually a rejection and then a new offer. The original offer is no longer alive. A contract comes into existence at the moment of acceptance, and the acceptance must normally be communicated to the other party to be effective. I'm going to give you some examples of these so that it becomes a little bit clearer. If a method of acceptance is specified in the offer, then it is mandatory. So if the offer states that acceptance must be sent in writing, a phone call or a text message doesn't form legal acceptance. Very often it's not specified. And if the method of acceptance is not specified, then any manner that is reasonable in the circumstances will do. And a court's going to consider several factors when deciding if the form of acceptance is reasonable. If an offer, for example, for computer services is sent via email, then a mailed letter of acceptance may not be seen as reasonable. However, it's up to a court to decide in a contract dispute, and this means there is some uncertainty. It's a lot safer to specify the form of acceptance in the offer so that there's no room for interpretation. Acceptance can also be indicated by conduct, so not what someone says or writes, but what actions they take. There's a good case in your textbook that illustrates this. It's Low Limited versus Upper Clements Family Theme Park. You're not required to know this case, but it's a good example of where acceptance happened by conduct. In the case, when Low sent the crane to the theme park, it was assumed that he had agreed to the terms and was accepting them as they were laid out in the offer. This was despite the fact that Low thought the further negotiation would happen and that the price for the rental was yet to be determined. So his action of sending the crane was interpreted by the courts as an acceptance of the offer of the rental of the crane. If acceptance is done by mail and it is lost in the mail, then the postal rule, otherwise called the post box rule, applies. The postal rule says that acceptance is at the time of mailing as long as it's reasonable that mail be used to accept, regardless of whether or not it is received. So, for example, Yoko offers to sell her artwork for $300 to the first person who responds. Gian wants the artwork and sends a letter that same day accepting the offer. Unfortunately, the letter gets lost in the mail. Well, according to the postal rule, legal acceptance has happened despite the fact that Yoko never received it. When it comes to the traditional mailing of a letter through Canada Post, acceptance is said to have occurred the moment that it is placed in the post box, as long as the post was a reasonable way to accept the offer. The postal rule has also been applied to telegrams in some cases, and also when it comes to acceptance by courier. In these cases, the offerer could be bound to a contract without even knowing it. Given new forms of communication and the decline of the traditional mail system, the rule's becoming less relevant, but it's still good law, so something to pay attention to. There are different ways or different avenues for acceptance. They can be in person, so it can be verbal. It could also be in writing. It could be by mail, and we've talked about how the mail is a little bit different because of the postal rule. But it could also be through email, text, faxed. And in those cases, with instantaneous acceptance, the acceptance actually has to be received by the offerer. Acceptance in those cases is effective only when it's communicated. So if acceptance has not been received, no contract exists except for the postal rule. And let's use an email as an example. So email is considered to be an instantaneous form of acceptance. But if someone doesn't read their email, then acceptance hasn't happened. This is different than regular mail through Canada Post, where acceptance has happened the minute that it was placed in the post box. There's a key case here that I would like you to know, and it is Carlo versus Carbolic Smoke Ball Company. The key facts are these. Carbolic Smoke Ball placed an ad stating that anyone who uses their product and still catches the flu is entitled to a reward of £1,000. So you can see that this is an old case. It's from 1893, and it's in British pounds. Carlyle bought the product, used the product, and still got the flu. So she said, well, I want the reward. The company refused to pay, saying that there was no contract. And I'm quoting here from the actual case. The defendant raised the following arguments to demonstrate the advertisement was a mere invitation to treat rather than an offer. They argued that the advertisement was a sales puff and lacked intent to be an offer. They said it's not possible to make an offer to the world. Their big argument was that Carlyle didn't notify them of their acceptance. They also said the wording was too vague to constitute an offer since there was no stated time limit as to catching the flu. And then finally, they argued that there was no consideration provided since the offer did not specify that the user of the balls must have purchased them. So there's lots of areas they were arguing, most of them having to do with the 4 requirements of a legal contract. So they suggest that the advertisement was merely an invitation to treat. So if there is no offer, then acceptance can't occur. They said it's not possible to make an offer to the world. In this case, it was an advertisement in a newspaper that said, hey, anybody who uses our product and still gets sick is going to get £1,000. The thing we're going to focus on in this case for our current discussion is they argued that there was no notification of acceptance. So they said, okay, even if you say Carbolic Smoke Ball made an offer to the world, Carlyle never accepted the offer. So this was their main argument for why no contract existed. They also said that there was no consideration, and we're not going to focus on that for this case right now. The Court of Appeal held that Mrs. Carlyle was entitled to the reward as the advertisement constituted an offer of what's called a unilateral contract. They said that with a unilateral contract, she had actually accepted by performing the conditions stated in the offer. So she bought the smoke ball, she used it, she still got sick. The court rejected all of the arguments put forward by the defendants for the following reasons. Number 1, the statement referring to the deposit of £1,000 demonstrated intent, and therefore it was not a mere sales puff. They also said it is quite possible to make an offer to the world. The third one, which is most important for our purposes, is that in unilateral contracts, there is no requirement that the offeree communicate an intention to accept, since acceptance is through full performance. They also said that while there may be some ambiguity in the wording, this was capable of being resolved by applying a reasonable time limit or confining it to only those who caught the flu while still using the smoke ball. The court also said that the defendants would have value in people using the balls, even if they had not been purchased by them directly. The legal question here was, did a contract exist even though Carlyle did not communicate her acceptance? The resolution by the courts was yes, a contract did exist. By buying the product and using it as instructed, Carlyle effectively communicated acceptance. She accepted through performance. And the legal rule resulting from this case is that in unilateral contracts, there is no requirement that the offeree communicates an intention to accept, since acceptance is through full performance. This case is an example of an offer of a unilateral contract, though the court didn't expressly identify it this way. Through such an offer, the offeror promises to pay the offeree a sum of money if the offeree performs the requested act. For example, a company might offer a $200 reward to anyone who finds a missing laptop computer. Unlike the ordinary business contract where both parties have obligations, in a unilateral contract only the offeror is bound because the offeree can perform the requested act, find the laptop, or not. He has no obligation even to try. If he does find the computer and returns it, the contract is complete and the offerer is contractually required to pay. For obvious reasons, this kind of offer typically does not require people who decide to look for the computer to tell the company of their intention to do so. From the company's perspective, it's enough to hear from the person who actually finds the computer. So remember that these are unilateral contracts, and in a unilateral contract, the offeree does not have to give notification of acceptance. Some contracts where offer and acceptance are not really negotiable. A good example would be the contract you sign when you rent a car. The contract is usually quite long, and the terms set out in it are not generally negotiable. Another example would be a mortgage contract. In cases such as these, the customer agrees to a standard set of terms, and these terms usually favor the other side. You can be sure that when a car rental company has you sign a rental agreement, there's all kinds of clauses that are in their best interest. But you have to remember, the law expects people to take care of themselves. So if the terms are somehow unfavorable for the customer, the law probably won't intervene. This is why it's critical to read and understand the contract before signing it. Despite the fact that I know lots of people who just inherently trust their bank or the car rental company or the leasing company and sign the contract without reading it. Remember that the law expects people to take care of themselves. This means read the contract. I'm going to spend a few minutes now talking about electronic contracting, so basically e-commerce. Electronic contracting has presented new challenges to our legal system. It refers to conducting business over the internet. So you've most likely purchased something online, whether it be a physical product, music, movies, etc. Despite the fact that many of us have been doing business online for years, the legal system still has some gaps in it when it comes to electronic contracting. Here's what we do know. The same general rules apply. This means that we need offer, acceptance, consideration, and intent to contract. They have to be present in order for a contract to be legally enforceable. But what's less clear is where offer and acceptance actually occur. When there are uncertainties in online contracting, people don't have trust in the system. And if there isn't trust in the system, then people are going to be less likely to engage in electronic commerce. In an effort to facilitate growth and trust and build trust in electronic commerce, the Uniform Electronic Commerce Act, or UECA, has been adopted in Canada. So it forms the basis for all provincial and federal electronic commerce legislation. The intent of the UECA is to remove barriers to electronic commerce. Before regulation, people were much more hesitant to do business online because they simply didn't trust it. And it was thought that through regulation, we could instill confidence in consumers and encourage e-commerce. So legislation has removed some of the uncertainty about online contracting. For example, it states that offers can be expressed electronically. However, questions still remain concerning whether communications on a website are an offer or an invitation to do business. So the Act doesn't specify whether an electronic ad is an offer or an invitation to treat. And we talked about invitations to treat earlier in this module. So the assumption here is that they should be treated the same as other advertisements, not electronic advertisements. So if this were the case, we would assume that an ad we see online is merely an invitation to treat. However, there's an exception to this in that an advertisement can be an offer if it contains enough information for the person to accept without further negotiation. So if an ad shows in stock, it's technically telling you that with the click of a button, that item that is in stock can be yours. And some would argue that this constitutes a legal offer. However, courts haven't really ironed this out, and so it's still a bit up in the air. There are also uncertainties around acceptance. We know that acceptance can be made electronically through things such as an I agree button, but you need to remember that acceptance must be communicated to take effect, except for with mail. The Act specifies when a message is sent and when it is received, but it doesn't specify where an acceptance becomes effective. So unless electronic traders specify where acceptance becomes effective, the question of where an electronic contract is formed is going to be decided on a case-by-case basis. Law in the area of electronic commerce is evolving, and it's important to stay current if the organization you own or the organization you work for does business electronically. So that's it for this lesson. Next, we're going to look at the final two requirements of a legal contract. Do you remember what they are? They are consideration and intention to contract. Bye for now.